Good afternoon, and you're very welcome, folk, to one of our national spotlights events of Local Enterprise Week 2022. This event is featuring a spotlight on intellectual property, and we're hosting it under Enterprise Europe Network. Enterprise Europe Network is led out in Ireland by Enterprise Ireland, with other partners being Donegal Local Enterprise Office on behalf of the 31 local enterprise offices, Dublin City Chamber of Commerce, and Cork Chamber of Commerce. I suppose just a few words on the Enterprise Europe Network. It's a network of some 600 partners in over 50 countries, not only in Europe but around the world, and I suppose really has a reach of about 25 million SMEs internationally. An example of what it might do, just coming from one of our local events this morning, which was focused on exporting, we had tied in via Enterprise the network, EEN network, into Scottish Enterprise in Scotland, and or the EEN network in the UK, covering Greater Manchester and Liverpool, and also London, and they were there as advisors, giving the companies that we had at our export event was basic information, but also offering their services to those companies if they chose to go into those markets in Greater Glasgow, Greater Manchester, and London. So it's a network that provides a lot of contact and information, and also key areas around innovation and intellectual property. And as I've said, today we're focusing on the intellectual property side of things. We have a significant range of speakers, very, very esteemed speakers around the whole area of IP. And I'd like to now introduce our first speaker, who is David Hyde from the Intellectual Property Office in Kilkenny, who will take you through some of the basic concepts and understandings around intellectual property and some of the differences. So I'll now hand you over to David.
Greetings, everyone. Let me just see if I can share my screen first to get started. Okay. Thanks for the introduction. As the sign says, my name is David Hyde, and I'm from the Intellectual Property Office of Ireland. So we're the national agency that's responsible for intellectual property protection in Ireland, and we're part of the Department of Enterprise Trade and no, we're not Enterprise Trade. What are we again? Anyway, let me start into what I'm here for. So I'm going to give you a quick overview of what is intellectual property and the different rights and how you can go about protecting them. Okay, so our office is pretty much responsible for the protection of these rights across Ireland, and I'll just give you, if this will move, a quick overview of what intellectual property is. Okay, now some of you probably already have an understanding. I will just kind of take it from a position that most people don't. So what is it? Well, it's creations of the mind that is used for commercial exploitation. There's four main streams of intellectual property. Okay, you have trademarks, designs, patents, and copyright. Okay, and these are the four kind of intangible assets that are part of a company's intellectual property. Okay, and I'll just give you a description of how each one of these is. Okay, so first off, why is it useful? Well, two reasons. One, it gives you it gives you access to hold on, sorry about that. Hold on. It's still there. Okay, so two reasons why it's useful. You don't want to miss opportunities, and also you don't want to have to use or infringe on other people's intellectual property rights. Okay.
Difficulty there with David down in Kilkenny. I don't know whether it's his connection or his. Yeah, we might just, I don't know, Richard, I want to maybe put you in the spot. We might come back to David. So Richard, we might ask our next speaker, if you're available there, Richard O'Connor of Cruikshank's patent attorney, who was lined up to sort of fitting IP into your business plan and somebody debunking some of the IP myths. So Richard, if you're happy to come in there and fill the spot a little bit ahead of time.
Yeah, sure.
Thank you very much.
Hi, everybody. I hope you're well on this day. If you're in Dublin, you'll know it's pretty biblical out there, so stay safe. Just to maybe take up on what David was probably going to run over, it was what is IP and what is its form. So basically, one definition is it's an idea of the mind, as he said. The next part of the definition is that it's protectable by law. So in other words, that there is a law that protects it. And then the third aspect is that it has commercial value. So somebody will actually pay you money for it. The reason why that definition is useful is because it will help you distinguish between what's a business idea, as in an idea to do for a business, and what is actually intellectual property, because business ideas are not protectable in any way. So if you have an idea, you have to figure out which form of intellectual property is the correct form for it to be protected, if indeed it is protectable. If you're dealing in inventions, you're talking, or technology, you're talking about patents. If you're talking about brands, logos, names, you're talking about trademarks. If you're talking about the aesthetic features of products, so the shape, the look, the feel of products, then you're talking about designs and registered designs. And then copyright obviously is usually applied to works of artistic merit, but in an industrial setting also applies to things like company brochures, literature, apps, websites, that sort of stuff. Okay, so that's what we're talking about when we're talking about intellectual property. One thing that I'm going to talk about briefly, and I'll share my screen now in a second, is the idea that we tend to think about rights, and intellectual property rights are no different than this, as the ability to do something. So they tend to be quite positive rights, if that makes sense. But in actual fact, intellectual property rights are different in that they are negative rights. They allow you stop somebody else doing something, not the other way around. They don't grant you the right to do anything. They grant you the right to stop somebody else doing something. And that's important in context of what I'm going to talk about. So I'm just going to share my screen now. If you bear with me, technology might get the better of me. And indeed it is, but not to worry, we'll get there. Okay, that okay? Can everybody see that?
Looks good.
Great. Okay, so needless to say, I'm now having the same difficulty that David was having, and the PowerPoint presentation will not play for me. So bear with me 1 second. The good thing is I know it off by heart, but I'd like to be able to share it if I could. Okay, the PowerPoint presentation is not sharing for me, so I'm just going to have to.
Richard, if you open it, we might be able to control it from here. I'm told.
Okay. I'll just go back and share my screen again.
Yeah.
Okay, can you see that now?
Yeah. Can you, down at the bottom of it?
Okay, I've clicked approve.
Yeah. Okay.
Okay, super. So we've just got that slide there. It's perfect.
Okay.
So what I've decided to do is just talk very quickly about what some of the stuff that I regularly have said to me about intellectual property that I'm guessing most of you guys are in a business setting or starting off, or maybe you're well established. So you will have heard some of these adages or truisms. The problem I have is that they're not true, and they are in actual fact myths. So one of the things that I would hear frequently is that you can always design around patents, so that if somebody has a patent it is always possible to design around it. Apart from the fact that that's not actually literally true, it also doesn't make a whole heap of sense. If you consider that a patent is a monopoly granted in a country to allow somebody manufacture, distribute, assemble, or sell, then it is used to stop somebody else from doing that. So if you can imagine a patent as a kind of a roadblock that stops somebody from doing something, if you come up with the best way to do something or the best design for something, having done research, etc., and you get a patent for that, that allows you to prevent somebody else doing it the same way. And yes, they could do it a different way in theory, but that's a bit like saying that the best way for me to drive from here to Sligo is through Athlone. But if my patent is a roadblock that is erected in Athlone, I can no longer now drive through Athlone and I have to drive through, shall we say, Roscommon town. That means it's going to take me a half an hour extra to get to Sligo. Adding 30 minutes to my journey, which is normally about a 2.5 hour journey, is adding 20% to my costs, 20% to my time and everything else. So economically, while you might be able to design around it, while you might be able to design around it, you won't be able to do it economically. And it's important to remember that. The next thing that I often hear is that there's no point in patenting something if you can't then defend the patent, as in if you don't have the money to defend it. That again is just doesn't make a whole heap of sense. So that's a bit, I think it's the equivalent of saying, well, I've never had a car crash, so I don't need a seatbelt in my car. You know, what's going to happen if somebody does infringe your ideas, if somebody does try to steal from you, if somebody does try to rip you off and you haven't filed a patent? Well, then you can definitely do nothing. That's the first thing I'd say about that. The second thing is that how are you going to know whether or not somebody doesn't infringe you, doesn't copy you, or doesn't try to rip you off because you had the patent in the first place? You know, you're never going to know that. And I did have a client come to me one time and say, when we got to the 20th year of the patent application and they were paying the final renewal fee, that this had been a shocking waste of money because nobody had ever copied them. Well, sorry, that's the best patent you ever get when nobody copies you, you know, and that's really what you want. But we'd often hear in our business that things like, you know, doing business in China is very difficult and you know, they'll rip you off no matter what. And that's usually in situations where they haven't filed it for any rights in China, you know. So you really have to be mindful of the fact that if you have spent money and invested money and R&D and everything else that goes with it, you really need to consider what you're going to do to protect that. So if I buy a new machinery, your new car, whatever else, I'm going to insure it, you know, and that's really important. So I'll come back to that as I sum up. The last myth then that I hear is that that I've registered my name with this company registrations office, and I have secured the domain address. So therefore, I'm free to use that name, and I have protected it. No, you haven't, and no, you're not. Okay. What you've done is you've secured a registration of a name at the company registration office. That doesn't grant you any right whatsoever. In fact, I'm quite certain that I could go to the company's registration office today and register McDonald's as a name for my business. But if I open up a fast food joint, I'm pretty sure McDonald's are going to be able to stop me. Okay. So, you know, why will they be able to stop me? Because they've got registered trademarks. Okay. The other thing that we hear that's on that point is that, well, I've checked, nobody else is using this, so I'm okay to use it. Well, we always ask the question, and sometimes we sound a little bit argumentative, but we always ask the question, well, where have you checked? And people will say, well, we've checked online, we've checked the internet, I've looked around, there's nobody else using this name. And we say, well, have you checked at the Intellectual Property Office of Ireland? Have you checked at the EU Intellectual Property Office? Have you checked at the UK IPO, for example? Britain are no longer part of the EU Union when it comes to trademarks. Have you checked these things? Because if you haven't done a trademark search, well, then you can't say that you are free to use it because you don't know. And the problem there is that if you start using a trademark that somebody else has already registered and therefore monopolized, they will be able to stop you from doing what you want to do using that trademark. Again, they're negative rights. So it's, in essence, what that means is if you've done any websites, if you've done any apps, if you've done any brochures, if you've done any letterhead, you're going to have to change all of those and start again. So why would you not check with the various intellectual property offices and do proper searches to determine whether or not you're free to operate in the first place? It would seem to me to be a bit crazy. Okay, so I guess then if we can move on to the next slide. I guess what my message to all businesses, no matter what stage they're at, is that what you have to do in terms of when you're writing your business plan and when you're trying to figure out what is the relevance of intellectual property to me, is you first have to, before you do anything else, is identify what intellectual property you have, okay? And that doesn't cost anything. People often say to me, well, how do I know what my intellectual property is? And I kind of say, well, look, why does your customer buy from you? What makes you unique? What makes you stand out? What makes, you know, the phone ring? What makes the website orders coming in? Whatever that is probably valuable. Now, that might be because everybody loves Mary Murphy and Mary Murphy's the best person in the world and everybody just does business with Mary Murphy irrespective of what she's selling, in which case, you know, it's your own personal skills, and that's fine. There's nothing wrong with that. But it might also be because people can remember your name really well, or you've got a clever, you know, name. I remember once hearing about a trademark for what you call them, event management company. It was called Ovation. And I always thought that was a really clever name for an event management company because it kind of sums up in your head what you want to get from the event, you know, huge rounds of applause. So you identify what your intellectual property is first. The next thing then you do is you put a value on it, okay? Now, I'm not talking about getting a professional valuation, although you can do that. But I'm talking about, is it important to your business? And if it is, and if you say, okay, no, this is important to my business. Without my business, without this in my business will struggle. Then you should protect it accordingly. And by that I mean, now, and by the way, I am a card-carrying capitalist, right? This is about the money, okay? What money is this piece of intellectual property generating for your business, okay? And if that money is €0, then you should spend €0 protecting it. I think it's a fairly simple decision. If, on the other hand, though, it's about, you know, it's generating a couple of €100,000 income, well, then it's probably worth spending a few €1,000s protecting it. You know, I think it's a relatively straightforward decision. But the first step, and I go back to this, is you must first start off by identifying what IP your business has. Thereafter, when you're writing your business plan, you need to keep it simple and remember that intellectual property, and the question that, you know, you're going to get asked over and over and over again as you go through the registration process, as you go through the prosecution process and so on, is what is the market? Where is the market? What are you trying to sell? Who are you trying to sell to? And where are they located? It's all about the market. And if you were to remember one thing about intellectual property, and again, I'm sure Dave would have covered this, is that intellectual property rights are granted by individual governments in their own jurisdictions. So if you're selling Hurley sticks, for example, well, Ireland is probably the only jurisdiction that's really of any relevance to you. So you only need intellectual property protection in Ireland. If, on the other hand, you're selling telecommunications, phones, for example, then you're going to need intellectual property protection in lots of other jurisdictions. And in terms of writing the business plan, you need to understand then, therefore, that your cash flow is going to be affected by whatever filing policy you take on. So what I finish with, and I hope I've covered everything sufficiently for people for the moment, is talk to an expert, engage with somebody that knows the answers to the question. You'll find most firms of patent and trademark attorneys will meet with you, well, probably virtually at the moment still, but they will meet with you for free with the initial consultation to help you identify your intellectual property, help you figure out what's the right route for you to take, and help you with these things. So the help is out there. It's just for you guys to go and get it. Hope that helps.
Thank you very much, Richard. We haven't got confirmation yet that David's back online, so we'll move to James. And I think picking up on that very point Richard made there about the importance of talking to somebody and getting that advice. Our next speaker is James Walsh from the EUIP Help Desk, and he's a Help Desk ambassador. And James will outline some of the supports available and the information available from the IP Help Desk. You there, James? Thank you. Oh, it's James. Yeah.
Bear with me. Yes, I'm here. And welcome everybody, and thanks for joining today. Can you see the presentation okay? It's displaying properly, I hope. I'm assuming that's yes. Yeah. So yeah, who am I? I'm James Walsh. I'm an ambassador, in other words, an Irish contact point for the EUIP Help Desk. So I'm going to talk in detail about what the Help Desk is and how it can help you. So I'll run through a set of slides fairly quickly, and there's a lot of content to follow up with. It's all aimed at SMEs and startups predominantly, and it's for you, and a lot to leverage out of this content, I hope. So a little bit on the background and the kind of resources. The European IP Help Desk, it's funded and has been established for a number of years by the European Commission. It provides free of charge first-line support on intellectual property, and I'll come back to that in a minute. And who does it service? All EU SMEs, including all you guys, another cohort of, I guess, target beneficiaries are any company, academic institution, etc., who are funded under any EU-funded project, or in general, the research community. So it provides, I suppose, essentially 6 kind of pillars of service. And they're kind of listed here on the right. I'm going to go through each of them in a little bit of detail. I've highlighted on the right the website as the first port of call, and with a few asterisks. Essentially, if you dive into that, and it's very user-friendly, you'll be able to get to all of the other parts of the services, I guess. So just touching on what Richard just said about the nature of IP and its protection, there's no such thing as global protection. In effect, you essentially have regional protection. And to meet that need, there are a number of these IP help desks. There's the European IP Help Desk, which I'll focus on, but as you will have heard, the nature of IP and its protection is regional, as is the commercial aspect, the issues in relation to market access. So each of these help desks for China, India, Africa, Southeast Asia, and Latin America provide incredible resources, people, expertise. Everything here today is pretty much available and more for each of these markets. And I'll reference how to access this a little later in the presentation. So first I'll talk about the helpline. I don't like the name help desk or helpline for that matter, because it's more than that. I think it's potentially for legal reasons that they've chosen the name, because it's free. It's European Commission funded, but it's not intended to displace professional advice. It's really there to support the initial dipping your toe into, I guess, for those who are not immersed in IP and the nature of it. So essentially, one service is this helpline. And if you had, let's say, a query on, I don't know, kind of contractual issue, where to go to, how to, you essentially can, either through me or directly through the help desk, write an email. That's the best way, and you'll get a response on your query. And it's very straightforward. Sometimes they get thousands of these per year. So that's a useful primer. But this is an incredibly busy slide, and it's really to just kind of talk to, and I'll move on for it immediately. But the idea of that slide is to show the amount of content and support that's available through this resource. And the first thing I'll talk to are the training services. So this is a central pillar of the activity that the help desk provide. And it's free, it's mostly online, it's available to you, and it's essentially goes from really, I would say, introductory concepts around IP, a little bit like Richard is speaking about there, let's say the introduction to, patents, trademarks, design rights, all these terms you'll have heard of, to very specific and more sophisticated content around things like, let's say, artificial intelligence and the ability to protect that through the intellectual property system. So, it's ongoing. This slide here on the left, on all those dates, if you go to the website, you would see under events all this training content. If you want to dip into any of it, it's all recorded, and you can, after the fact, just click on each of these and get a sense of the content. So, for example, it's the relationship between patenting and innovation, the importance of IP for SMEs, commercialization and licensing. So there's the protection part and the exploitation part. The right-hand side essentially are a set of webinars around services provided, webinar training services provided by the international help desk. I mentioned, Africa, Southeast Asia, China, IP considerations when entering the Chinese market, for example. It's kind of, it was referenced by Richard on China, I suppose some of the debunking some of the myths, I guess, is probably one way to put it, and some tips on what's required in particular markets from an IP perspective, whether agents are required, what support you might need on the ground, and so on and so forth. Another aspect which probably is useful for the audience today, there's a huge amount of existing content, and this is written, I wouldn't say in layperson's language, but pretty simple, straightforward information on the nature that supports SMEs. They're called fact sheets. For example, most of you will have heard of non-disclosure agreements, and these kind of fact sheets give the whys and wherefores, why use them, tips on what you should do, the important clauses, what to avoid, when they're useful, etc. Likewise, with trade secrets, obviously closely related, and the nature of trade secrets, what they are, what they're not, and why they're important from a business perspective. And I think also very important, and I chose these as a subset of fact sheets were trademarks, very important to many of you, and the nature of them. I suppose, going back to what Richard said earlier, the kind of queries we sometimes get, just because people aren't familiar with the differences between the different types of intellectual property, can you trademark or invention, in effect, kind of mixing up the nature of the protection available. So each of these kind of fact sheets, along with events like today, are really a way to start that, training, education, so you understand, and can go back and reference each of these as needs be. In terms of, Michael at the beginning referenced the European Enterprise Network, and basically I'm part of that, and we provide additional services related to IP and many others, but from an intellectual property perspective, the kind of things that come up time and again, and we provide support, are things around you going to a trade fair, going to an event, what to present, what not to present, making sure you're prepared from an intellectual property disclosure point of view. So in general, you don't want to disclose before you're sure you're protected, at least, so that's part of that. And there are a whole series of, I've just taken this list, I don't intend going through it, but it's just to kind of give you a sense of the variety of activities from a business perspective that an IP opinion is of help. And that's where this help desk and people like me come into being. And there are resources. If I put the whole table on the slide, there would be various links on where to go to from here, but I can forward that separately. So really here, this is a busy slide, and it's the only reason to show this to you is you will have heard of a number of entities, like Richard mentioned the European Patent Office, the EPO earlier. They obviously are involved with the protection and registration and review of patents in Europe, but they also provide a lot of training around IP through the EPO Academy. Likewise, WIPO, which is a United Nations agency, funded agency, provides a whole lot of training content. So out there is a lot of support and content, somewhat overlapping with what the help desk does, but some people might prefer content from displayed in certain fashion. So they're all worth delving into. What's most important, though, I think today is from a European perspective, there are some financial supports available. And one in particular I wanted to focus on, I've kind of have it here referenced, which is the Ideas Powered for Business SME Fund. This is funded by the European Commission. It's managed under the EU Intellectual Property Office, the EUIPO. Essentially, companies, early stage or not, can apply for vouchers to part support the registration of trademarks, design rights, and the initial costs of filing for patents. That's just from January this year. So it's straightforward to apply, all that stuff. I would encourage you to have a look at the website because it's there. You can do, an agent can do it on your behalf. And there is a kind of educational kind of walkthrough support system through this portal to help you gauge whether trademarks and designs are, whether they're novel, whether they've been registered before. Going back to what Richard said earlier, you don't know till you start looking. There are resources, there are search engines here and available for you to do that. And there's additional personal consultation. So that's all I want to talk about from the resource perspective. The only other bit I wanted to touch on briefly was this ambassador scheme. I'm one of these European ambassadors, if you like. And what we're interested in is things like today, helping support you to build up your IP capacity, your understanding, and your ability to navigate this framework, which might be new to you. Hopefully to make the topic more accessible, and that's the nature, and all of the content that can be shared afterwards is meant to be that. But most importantly is from my perspective and from many of my colleagues' perspectives is really to understand what you need, So we run events, but in the absence of feedback from SMEs and startups, we can tailor these events to design them so that we get the right content developed for you. If you want a deeper dive, for example, on internationalization of IP, on software, on e-commerce, there's a lot of content available. So essentially, hopefully as part of the follow-up here, we'll be following up with you, and we'd be very grateful if you'd share with us where you would like additional content that meets your needs. And I think that's all I've got to say. These are my contact details. These are the links for the website. And the only final point I would make is social media. The IP Help Desk is very prolific and well-resourced from a social media perspective. So following on Twitter or LinkedIn, you will be reminded fairly frequently on developments, events, content that's useful, new financial offers. So I'd encourage you to follow both on Twitter and LinkedIn, and you will see what I mean, I guess. Okay, I'll probably leave it at that. And
okay,
thank
James.
you for your attention.
Thank you, James. And as you would hear from James there is a large or a vast amount of information out there and resources. So there's no problem finding them. But again, go back to probably what Richard has said and what James has said as well. There are those first point of contacts, either your help desk or you try and have a discussion, initial discussion with a patents agent. I'm going to go back now to David. David, you're there with us again. So hopefully you'll be able to stay with us for your 20 minutes, whatever, and you're going to take us through what is IP, the forms of protection, and maybe the application process.
Okay, yes, we'll try again. Much apologies, everybody. I don't know what it is. As soon as I hit share, this machine just doesn't like me. So look, you've taken in a lot at the moment, so I'll just cover a bit or break it all back down into the actual different forms of intellectual property. Okay, so we'll start with trademarks. So, and I know Richard has kind of mentioned this. Trademarks is the name you call yourself, okay? And we maintain the register for trademarks, okay? It is the definition is any sign capable of being represented on a register. Okay, so trademarks can be anything from graphics, words, verbal elements, and so on. Like we're all familiar. As soon as you put a name over the door of your business, you are creating intellectual property. Okay, you're defining a trading name, and that can be protected using trademarks. Okay, sorry if this will move. There's several different types of trademarks. I won't get too bogged down in it, but there is other elements, not just verbal and graphical elements. Okay, you can have trademarks for shapes of products. You can have positional marks, which is a new thing. And that's where you might see on a lot of garments where people are putting their logo in a specific location. And those elements of a unique identifier for a product can be actually trademarked. Okay. Now, trademarks you can consider in two different ways. You have unregistered rights as soon as you use the mark or put the name over the door of your business, okay? You don't necessarily have to get it registered, but you'd be using common law to defend yourself if someone else was to infringe on your trademark, okay? You'll see that TM on different brands around the place, and it's just an indicator to others that there's value in your name. It's free to use. Anyone can do it. You don't even need to register with us. And you'll defend it if someone uses it without your protection or without your permission, sorry, okay? Now, once you're registered, or if you decide to register a trademark, it's only then you're allowed to use that R in the circle, okay? Now, you'd obviously be dealing with us if you need to register in Ireland. I know Richard did mention that all intellectual property rights are kind of jurisdictional. So there is a national office like us in every country and a European level as well, and internationally around the world. So wherever your market is, that's where you should be considering trademarking, okay? The trademark gives you absolute monopoly on the use of the name. Now I will, I think the next slide will show you about searching to make sure that your trademark is available to use. Like you can call yourself what you want, as Richard mentioned, the company's registrations, but that doesn't necessarily mean you won't infringe on someone else's trademark rights if you call your business or your trading name is different to your actual registered company's name, okay? For trademarkability, you need 3 requirements. Your mark must be distinctive, okay? So it can't be similar to anything else that's out there. Can't be too descriptive of the goods and services that you're selling. And it can only be for the designated goods and services you're selling, okay? Because you don't get a trademark for absolutely everything. If you're only selling clothing, well, that's the class that your goods and services fall into, and that's what your trademark, that's where you would apply for your trademark, in that class, okay? Now, the best place to search if you're considering, well, if you have a business name and you just want to make sure it's not registered somewhere, is this database called TMView, okay? It's very useful. It is hosted by the European Union Intellectual Property Office, which are the European version of us, I suppose. They're the European entity that's responsible for registering trademarks and designs, okay? That database is very useful because it has national data in it. So it has our data in it. It has European data, and it also has international data, which is very useful, okay? So it's as close as you're going to get to a global trademark search, okay? And if you do nothing else when it comes to trademarks, if you're thinking of a name or you have a name, just make sure that it's not registered somewhere else. And it's also useful as well as if you think you're of expanding yourself into a different jurisdiction, you'll be able to see whether the mark is protected there or not. Okay. All the EU they do offer also an application process where you can file one application to European Union, and it'll give you all 27 member states. Now, unfortunately, England is not part of that at the moment. That includes the 6 counties in the north. So if you do want protection in the UK and Ireland, you actually have to deal directly with the UK office. Okay. So that's trademark. So like I said, once you put a name over the door, you have created intellectual property. Okay. You've created the right to use or trade using a specific identifier. Now we'll get into designs real quick. I know I'm talking fast, but you can have these slides later, and you can also talk to us later if you want. But I just need to get through all this to try and explain what the different intellectual property rights are. So the designs protect the shape of something, okay? The appearance of it, the contours, the materials, not the function, okay? The function is protected using patents, and I'll get into that at a later slide. Now, for something to have design characteristics, it has to have individual character, okay? So you can file designs for things, but it's really only a formalities check that we'll do on them. But if someone else's design is similar to yours, well, then the first instance of the design has priority, or not priority, has ownership of the design, really. So you have to be careful. Now, there is a design database. Again, it's hosted by the European Union Intellectual Property Rights, Property Office even. But again, if you're creating works by yourself, it's very unlikely that you are going to infringe on someone else's. It can happen, but it's very unlikely. So you can search designs to see what your competitors are registering, if that's the case, or you can just search that design to make sure what you're in the space for creating is not being designed by someone, or registered, I should say, by someone else. Now, with designs, they're similar in a way to trademarks in that you have unregistered design rights. Okay, a trademark you don't really need to register on at any stage of the business development, but it's a good kind of security blanket to protect your name, and it's worth doing if your reputation precedes you. Okay, with designs, it's a bit more strict in with the regulations. You have 1 year's grace from first disclosure of a design to actually register it. Okay, if you don't do that, you've got unregistered, or you'd be relying on unregistered design rights for a maximum of 3 years. Okay, registered design, you can stay registered for 25 years because it renews every 5 years to a maximum of 5 renewals. All right, and this was an EU directive that was brought out to protect kind of the fashion industry and other industries that designs kind of change or rotate quite frequently. So again, there's 2 types of designs, registered and unregistered. Okay. Now I'll get into patents. Now I know Richard has kind of covered this a lot, because that's his area of expertise. But for us, patents is probably the most misused word I've ever heard when we're answering calls. People want to patent their inventions or their ideas, and unfortunately, you can't patent an idea. But as you execute an idea, it may be patentable, okay? And it protects the function of something, the opposite to kind of design, because the design protects the form, all right? And it's the one intellectual property right that doesn't exist automatically, okay? You have to register it with us before you disclose it. Now, there's two core elements that something needs to have to be patentable, okay? It needs to have novelty and it needs to have a technical inventive step, okay? And without them, it's either a novel product or it's an inventive product, but if it doesn't have both of them, it's not patentable. Now, there is a database, again, to search if you are inventing stuff to make sure that what you're trying to create is not already there, or to make sure if you want to use something that is not on patent somewhere. And that database is called a SPASnet. Now, that's hosted by the European Union the European Patent Office, which is similar to the EUIPO in that they do the trademarks and designs. With the European Patent Office, it does patents only, okay? Now, it's slightly bigger than Europe because I think there's 35 member states, but they host that database. It's free to use, and it gives you a good idea whether or not what you're actually considering protecting if someone already has created something in the same space. Because at the end of the day, patents are never really inventions from scratch. They're kind of improvements on what's gone before, okay? And that database should give you an idea of what's been invented in that area. For us, a patent is just a document. It's not a prototype. You don't need any of that kind of stuff. It is a legal document, and it comprises of 4 elements, okay? You have a description, drawings, which reinforce anything in the description, and you have an abstract, which is just a short summary that's used for searching in that database, SPASnet, and you have a claims section, which has to capture the scope of the invention. And the whole thing itself is a legal document. So if it's not written right, it's not worth the paper it's printed on. And that's why we always suggest that if you are considering patenting, you do talk to patent agents and get their expert advice, because at the end of the day, they're the legal experts, we're not. And you want to make sure you have a robust patent to protect your invention. Okay. Moving on to copyright. Okay, so the first 3 intellectual property rights I spoke about, we maintain registers for them. With copyright, there's no real register, okay? And it's I suppose you call it a soft intellectual property right, but it's the right granted to authors of creative works, whether it's paintings, drawings, films, books, songs, computer programming is in there as well. But it relates to the expression of the idea, not the idea itself. Okay, so it's not that you can, draft a document explaining how to create a flying bicycle and think you've actually protected it. The idea, you haven't. Okay, that was your expression of how that bicycle might fly would be copyright protected, but not the actual invention. Okay, you need to actually file the patent if you have come up with that idea or concept, I should say. Like I said, there's no register for copyright in Ireland, okay? It's an automatic right. So how you protect is pretty much documenting date of creation, okay? Anything that can stand in your favor that says you created something, a work of art or a blog or a photograph or a piece of music at a specific point in time that you could use to defend it is how you defend or protect copyright, okay? So you just build up a portfolio of when you actually create works and document them. Obviously, the modern poor man's copyright is to electronically send it or post it through third-party infrastructure to actually make sure that it has a date that's not editable by yourself. When you're writing or documenting copyright, it's simply just use that C in the circle, copyright, who owns it, and the date. And that's a good indicator to others that the work is actually created by, or who the work is actually created by. Okay. So just to sum up what the 4 or 5 different intellectual property rights, main intellectual property rights are, because I didn't touch on really know-how, and that is something that's for a different talk. Anyway, so the humble honeypot that you see in the supermarket. Okay, the example here we have is the Boyne Valley one. So you have trademarks going on for the product name, and obviously sometimes the company name as well. All right. Patents. In this instance, the non-drip cap was originally patented. Okay. Now, Boyne Valley probably didn't invent that. They just licensed it from whoever did, and it improved their product. Okay. So it's an example of how patents are not really, can be license to others to make money rather than just being a source of something that you want to create yourself. Okay, and we have copyright for the graphics and texts on the actually cover of the product. You have designs for the shape of the actual product. Now, you'll see a lot of designs on the shelves, in the honey shelves, kind of all similar. Some of them will be similar to imply that it's a beehive style shape to it. But again, if the design is protected, you can't be use the same one. Okay. And you have trade secrets in this instance, which is kind of know-how. And that's how, you know, you keep certain recipes and blending of honeys in-house and you don't share it with your competitors. Okay. Now, I know James spoke about this, and this is very useful. You'll find more information on this on our website or on that email web address. And this is where you can get money from the European Union Intellectual Property Office, which is EUIP. And I think there's 3 streams, let me see, of vouchers that you can get. Okay. You can actually get 50% or more. I think it's 75% of your registration fees for trademarks and designs. You can also get a pre-diagnostic service or evaluation of your company or business. And you can get, I think it's up to 50% of or 500 euros of fees towards patents if you're filing patents. So it's very useful. It's available to SMEs across Europe. So really, if you are considering filing trademarks, designs, or even patents, it's worth registering with the SME fund or the Ideas Powered thing, because it's literally, you'll get money back for filing fees. So it's a no-brainer. Sorry, now this last one, if it's working. All right, that one. So this is what we look like. Anything I've spoken to you about, you can find out more information on it by clicking on any of the icons. And the white part, if you are considering filing trademarks or designs or patents, you can do this online through our website in the blue box in the right-hand corner. So there's no need to call to the office. You can do it from home. So it's all very straightforward. I won't say it's foolproof because we haven't met every fool, but there is tools on the online services, the registration services, to help you get your trademark registered or get your trademark application correct, and similarly filing patents, what's needed formalities wise. Okay, and that is me. Sorry for talking so fast, and apologies for losing contact earlier on.
Okay, thank you very much, David. Can I just, I know this, we've said we might hold off on any questions and answers depending on where we are. Just you outlined there the 4 elements of the application. What would be an application? Is there a template application form available from yourselves, or do you advise against that?
No, we do have a template tool for filing patents. Sorry, and it's on our website. So if you apply through our website, you'll be asked what you want to apply for. If you say patents, you can in the actual application process, you're asked then, do you want to upload your document, or do you want to use the tool that assists you draft the document? If you go into that option, it helps you break down what the application will look like, and it actually separates out those 4 elements and ensures that you kind of put in content in the correct way, and then it all kind of compiles the patent document for you at the end and allows you then upload it into the online application filing system then. Okay, so it's very useful, and even if you have something pre-drafted, it'll help you cut and paste it into the correct fields so that you can file a.
Okay. No, appreciate that. Thank you very much. And thank you for overcoming the difficulties there you had earlier on. Okay, so our next speaker is Joe Doyle, Head of IP in Enterprise Ireland, based down in Shannon. And Joe's going to talk about some of the supports available, particularly from Enterprise Ireland, but I think some of them may be also common through the Leo or to Leo clients. So I'll hand you over now to Joe.
Thank you, Michael. I hope everyone can hear me okay. And good afternoon, everyone. As Michael said, I'm the IP manager in Enterprise Ireland. So I work closely with James as well, but I'm in a slightly different sort of area. So if I just get to share my screen here, it should come up. that's the wrong one. Okay, so hopefully you can see my screen now.
Yes.
Good. Okay. So as I said, good afternoon. It's great to be here, and thanks for the invitation to join the webinar. I work for Enterprise Ireland, like James, and we work very closely together. But I'm in an area that supports companies around research, development, and innovation. And my job is to add IP support to that, because client companies of Enterprise Ireland and local Enterprise Office companies that are conducting research and development kind of are by definition creating intellectual property. And so we have some IP supports to help those companies to protect that intellectual property, and ultimately to develop an IP strategy to help them exploit the value that's created through their innovation. But Enterprise Ireland is all about supporting companies to grow, and similar to the local enterprise office. So what our supports are very much focused on is how to support companies to generate business value and to grow their business by using intellectual property. So I'm going to explain a little bit of that first. So intellectual assets. You can think of a business much like an iceberg. There's some stuff that appears on the balance sheet of the company, and it's maybe your tangible assets, and it can be accounted for quite easily and can be, quite visible in the company. But there's stuff that's underneath the waterline, and that's very hard to communicate sometimes. A lot of it doesn't appear on the balance sheet. So it's this sort of intangible value that exists in a company. And these days, more than 80% of an innovative company, more than 80% of the value of an innovation-led company is in intangibles. And that's where the IP system comes in, is to help a company to protect that value that's created as intangible assets for the business. And intellectual property, as David and Richard explained, comes in lots of different forms. So there's a lot of value created in companies that might exist below the waterline and that needs to be protected. So when it's a small company, it can be, while it's a large proportion of the overall value of the company is still relatively small. So it's quite easy to ignore that at an early stage. But as a company grows, that amount of value under the waterline also grows in proportion. And as companies scale, managing that intangible value becomes an ever bigger problem. And it's really when companies get large and when they're successful and when there is profit being made, that's when competitors start to pay attention really to the company. And very often at that point, it can be too late to protect the intellectual property. So it's something that companies need to think about at an early stage. And if you have ambition to grow, to be a large company, the time to start thinking about protecting the intellectual property is at the early stage, or starting it as soon as you can. And ultimately, what you need to do is have an IP strategy. So what an IP strategy says, it's how your company looks at the intellectual property that you're creating in your company and the intellectual property in the marketplace that you're working in, and developing a strategy that helps you to grow your company using intellectual property. So I'm just going to reference a few reports here that hopefully show that there are good reasons to do this. And really, there are good reasons for agencies like Enterprise Ireland and the local enterprise office network to support companies to protect their intellectual property better. So first of all, you can see here that SMEs typically don't protect intellectual property, at least to the same degree as larger companies. Less than 10% tend to own registered IP. So there's obviously more than that doing innovation. So there's a large chunk of the SME population that are not protecting the intellectual property that they should. However, the ones that do have been shown to exhibit much higher growth potential. For example, an SMEs with intellectual property have been shown to have 68% higher revenue per employee compared to counterparts that don't own any IP. So that's across a very large sample of companies in the EU. And it's not a causative relationship, it's a correlation, but it certainly shows that there's something in it. The correlation is also much greater for SMEs than it is for large companies, which is interesting, because what it possibly shows is that SMEs are in fact a lot more innovative, and a lot of disruptive innovation comes out of SMEs. And so there's a lot of value and potential in intellectual property, and companies, SMEs in particular, should be aware of it. Also, there was a study done, I think it was 2019, by the European Patent Office and the EUIPO that had been mentioned earlier. And they did a retrospective study on companies that exhibited high growth characteristics. And they looked back at those companies and said, you know, which companies protected their IP from an early stage? And they found that there was a cohort within that group that protected their IP from an early stage and later achieved this high growth characteristic. And they tended to be companies that were innovative and risk-taking, exporting, and internationally active. They tended to have stretched resources because of the high growth that they experienced. And they were also based on human capital, research and development, and intangible assets, otherwise known as IP. So these are a very important subset of the SME community, because during their high growth period, they contribute disproportionately to employment growth. And essentially, this is why agencies like Enterprise Ireland and the local enterprise offices are interested in supporting companies to innovate in the first place, but then also to protect the intellectual property that results from that innovation, because they contribute in a large amount to the economic development of the country. Just looking at that in a little bit more detail, that study showed that companies that did protect their IP at an early stage were, you know, between 17 and 26%, depending on their level of growth, more likely to achieve high growth. In turn, and there's quite a lot in this slide here that I won't go into in great detail, but they did show that, you know, companies that protected patents at the European Patent Office were significantly more likely to achieve growth. They showed that it was consistent across different sorts of sectors, from consumer durables and non-durables, and also the companies that used a wide range of intellectual property rights, in other words, that they had a broad IP strategy, were even more significantly more likely to achieve high growth. So that data is kind of important background for the case for Enterprise Ireland and local enterprise offices, and I guess the state, to commit taxpayers' money to supporting companies to protect their intellectual property. And essentially that's what we're doing through the Enterprise Ireland IP strategy supports. So I'll just explain a little bit of what that is and how it works. So the IP strategy offers a grant scheme that falls under our research, development, and innovation supports. So some of our offers are available to local enterprise office clients as well. We support companies to do research, development, and innovation. And those supports, they're financial supports for companies to do an R&D project, and that the R&D project supports their innovation strategy and the growth plan of the company. So the R&D is always about growing the company. The IP strategy support comes in under that to help the companies to conduct an IP strategy assignment around their R&D activity, and to build an IP strategy element into their innovation strategy, and ultimately to use IP then to grow the company. The supports have two main objectives. One is to help companies to access the external expertise. Richard mentioned it earlier, that it's really important to obtain appropriate external expertise to help you to address whatever the IP particular requirements are for your business. It is a complex area, and there are a lot of pitfalls along the way in doing this. So it's really important to have good support to do that. So what we try to do is we support some of the companies with some of the cost of accessing that expertise. But the other objective is to help companies to develop internal IP awareness and capability, because a lot of what your company needs to do around IP is stuff that you can actually do yourself. It's in-house IP management. It's things like confidentiality. It's documenting your R&D results. It's engaging with third parties strategically and being aware that there's IP involved in whatever you're sharing with companies, and to be very strategic about how you engage with those third parties. So there's a lot of stuff that any company can do. And if you develop that discipline, then you can also engage with the external experts in a much more effective and efficient manner. So the schemes themselves, this slide summarizes the main points. Essentially, it's available to Irish companies that are clients of Enterprise Ireland, local enterprise offices, or Rúdhras na Gaeltachta. They have to be doing research and development because we feel that that's where the most valuable IP is generated. There has to be a need for IP support, and these companies have to be export focused. And there are two grants. There's the IP Start grant, which is a small grant, relatively speaking, but it's a high grant rate. And the idea there is to help companies to get a foothold in something, to address some discrete IP challenge, because a lot of companies don't quite know where to start in this. So the IP Start grant is there to kind of give a shot in the arm, to take something on and to build from there. The IP Plus grant, on the other hand, is a 50% grant toward an expenditure of 70,000 on developing a broader IP strategy. So that's building IP strategy into the business development strategy of the company. And there are two elements of cost. There's a company can spend up to 50,000 on external IP expertise, and up to 35,000 in terms of internal capability in the form of an IP champion. Now that they don't add to 70,000, as you can see. So this idea requirement for external expertise and their ability to commit internal resource to developing the IP strategy. So there are some links there, and the last part of that slide is where you can find some more information. There's an email if you want to get in contact to find out more. And there's an expression of interest if you want to just set out some of the challenges that you might have. So those are the grant schemes that we have available, and that's how we're trying to help companies to build their IP strategy at the moment. As I said, it is available to R&D performing NEO client companies. So there's one final thing I want to mention to you before I finish up. There's a lot, it's already been mentioned that there's a lot of information out there for SMEs and companies around intellectual property. And I just want to highlight this one initiative that's been run by the European Patent Office and the Licensing Executive Society. So this is an international IP awareness activity, and they run a number of forums. You can see them coming up there and the different dates that are on. And they focus on a specific area of IP strategy. They tend to have very good speakers and they do case studies. So they're really good information events if you want to learn about a specific aspect of IP and IP strategy. So I'd recommend following the links there to register for them. They're free to attend, and I would definitely recommend the quality of the events. So that's really all I've got to say. And happy to take any questions when we get the opportunity.
Okay, Joe, thank you very much. We are just a few minutes ahead of schedule, so I know there was one or two questions came in there on the chat. Maybe it might be David or Richard. First one was, they want to register the name and a logo. Do they need to register 2 trademarks to cover that, or just the one?
Yeah, I see that. That's from Lorenzo. Yes. So yeah. The answer is both, unfortunately. I know that's a bit of a cop-out, but really you can apply for a trademark for both verbal and graphical elements together. That's called a combined trademark, or you can do them separately if the word is more important or the graphics more important. The way you should think of it is, which is the most valuable identifier for the business? Is it the combined two elements together, or is it the graphic or the verbal element? So I can't give you a steer on that. It really is what you think is the unique identifier for the business, but there is a facility there to apply for trademarks that are a combination of graphic and verbal element.
Okay. Yeah, there was one other question then. I think there was a question in there around, I suppose, it can, and then how could you protect scripts or case studies that have been written in collaboration with others? Is it something that you could protect? And just from my own minimal knowledge, I'd be saying that might be difficult, particularly if you've done it in collaboration with others. But then if you can, how do you do it? So anybody want to take a quick shot at that one?
Yeah, I'll have a punt.
Richard.
Yeah, thanks, Richard.
It's very challenging, very tricky. First of all, ownership is the question. Who has contributed? Copyright law is, in some regards, is kind of the easiest to get your head around, but it is also in some instances the hardest to really understand. So you have varying degrees of ownership. The long and the short of it is that it's not really protectable, because how are you going to enforce it? Very, very, very challenging. And because copyright is what we refer to as an unregisterable right, then there's also you're basically straight away into the High Court. So my advice would be to make sure that you have everything in writing as to who owns what, and mark on it that it is copyright material, and that if that's basically what I refer to as the drooling Doberman of intellectual property. So in other words, you put a symbol up there, as David advised, and it's basically saying to somebody, if you break into my house, you have the drooling Doberman to deal with. The fact that you might only have a toothless budgie defending your property, well, that's a separate issue, but they won't know that when they decide to infringe it. Hope that helps.
Yeah. Okay, Richard. Thank you.
Can I just add something to that?
Yes, Joe. Absolutely.
One very important area of IP management is having agreements in place with the people and the companies that you're working with. So I don't know what the situation with this specific inquiry is, but from as early as possible, when you're working with other people, just try to put an agreement in place that stipulates what's going to happen with the IP, who's going to own it. If it's owned by the creator, are they going to continue to own it, or do they need to license it to the other parties? So one way or another, if you're working with third parties, you will need to have legal agreements in place with them around the IP. And it's not a formal type of IP protection, but it is a protective strategy to apply when you're working with other companies. Okay.
Thank you, Joe. I'm just conscious of time. There's a few more comments in there in the chat box, but our last speaker, I'd like to now bring in Claire Ryan from ITIS, who is, I think she described herself when we were doing the rehearsal as if we're still in the early stages of this process. So again, it might be no harm, I think, for some of our listeners or some of our participants to hear what her journey so far has been. So Claire is a local firm in Donegal, so I'll hand you over to Claire.
Brilliant, Michael. Thank you so much. I've not got any slides, so I hope you won't be too disappointed as I go through this. But yeah, my learned colleagues who have joined me definitely have got IP bolts and braces on and know it inside out. As a startup co-founder, it's not something I'm overly comfortable with. Even at this point, there are two co-founders in our organisation, and I suppose a little bit of a background is we started here locally in Donegal through one of the early stage kind of development programs called New Frontiers. Now, since we've started, we've gone on to develop a piece of technology. So we have a machine learning driven data aggregation platform, which is able to predict the likelihood of a cyber incident happening in a small business. And what we do is it generates a score from that piece of technology, and that piece of that score actually is used as an additional data point with the insurance industry for insurance purposes. Okay, so without being too tech heavy in all of this, you can understand that there is a complex mechanism around the IP that would go with that. Whenever we started out, but like probably many people on the call today, you're very much encouraged about get your product into the marketplace, get out there, talk to customers, build your sales pipeline, focus on those tangible assets that Joe mentioned there in terms of building your business. And the idea and the innovation that sits behind maybe the other side of your business, maybe the side that you're trying to bootstrap, for example, is always kind of parked in the background and never given the attention that it should be given. And that's certainly where I was at the beginning. And it did come back to bite. It very much did come back to bite on me. And a couple of my colleagues here had mentioned about seeking the right information and talking to the right experts, because I think whenever you're starting out on a business journey and creating a new business and creating a new product and trying to get it into the marketplace, there are lots of conversations that you will have with people. And there are lots of armchair experts who are the wrong people to listen to, particularly if you have a tech product. People will tell you it's not something that you can patent. There's no point going down that route. It's a SaaS-based product, so you can't do anything with it. And that's not always the case. And what happened to us in particular was we did focus on the tangible assets, and we got out to speak to people and potentially speaking with investors who would like to come into our business. And in that process of chatting to people, you naturally get into what your product does and where it goes, etc. And we had an experience where it didn't go the way we wanted it to, and we ended up having to take some legal advice. And the first thing that came back at us was, where's our intellectual property? Has a patent been filed? What non-disclosures do we have in place? What have we done to actually claim what we were building? And how could we prove that if things went horribly wrong and someone else began to infringe on our idea? So as a result of that, I actually did take a step back and start to think more strategic about where our company was going, because we do have global ambitions. We do want to take this into new jurisdictions, and we want to make sure that we're protecting our ideas that are wrapped around that. And we've begun now to build out that IP strategy, and we are at the early stages. So we started to look now at freedom to operate. Are we going to infringe on anybody else's intellectual property that's already existing out there that could come back to bite before we plow huge amounts of money into further development? We're looking at our trademarks and having those registered. And as some of my colleagues mentioned, because the UK is a significant market for us, we're now looking at doing that in both Ireland and the UK. And we've begun to really look at how we interact with our team members and people who helped us along on our journey. So our development team, for example, are sitting in Eastern Europe at the minute. And we have contracts in place with them, but we want to be sure that everything that is happening in further development with our technology remains our intellectual property and can't be exploited anywhere else. We also want to be open and clear with our own employees, because employees will come and employees will go. We'll have new additional founders come into our team and help build it, and maybe they'll move on. But we need to protect the company and the intellectual property that we have, and protect the investors then who come in and join us on our journey to make sure that nothing is taken advantage of because of a lack of oversight that I've had. So I know it's been mentioned a couple of times and I've said it already. Definitely reach out and ask the right people. There are a wealth of different resources that are available out there if you simply ask. Don't undervalue investing in having those experts have that conversation with you. Even if it is the case for us that we'll not go down the route and lodge our IP or it wouldn't be granted, I would rather have an expert come back and tell me and help me understand why that's the case than something maybe that I've read off a website and misinterpreted in my own right. I do think it's something that most startups and most small businesses have a challenge with. If you're a university spin out, you probably have access to it. But for the rest of us, we're navigating so many things at the one time, and it's about putting true value onto the different areas of your company. Joe did mention there about the intangible assets and how much you're worth to your organization. And for someone like ourselves who is just early on that journey, particularly in tech, that's going to be the bulk of our wealth in our company, and it is worth investing on. It's easy to say that the marketing activities will turn sales, but we should also look and be able to prove that we've done everything that's possible to make sure that we protect the assets that we have. So that's where we are roughly on our journey. I have been bitten in the past. I do regret not looking at it at a much earlier stage. But even for us now, been 2.5, 3 years into this, it's not too late to start. And I suppose maybe that's something that should come out from all of the guest speakers today. You can start the IP journey now. Even if you've been already operating and doing something in the background, it's just a case of reaching out and asking people, where do you get started and how you go with it. I chatted with somebody who has recently registered some IP, and people are really, really helpful if you want to reach out to other companies who have done this process to guide you. And the best piece of advice they had given me was, even if the patent comes back as not been accepted, you still have patent pending, and you have a tangible evidence that you've gone through that process and that you're not going to get it. Okay, rather than just assuming that you wouldn't get it, you've actually gone through there, and whilst that process is moving forward, which can take up to a couple of years, you're still first in the queue if they do decide to award it. So you're going to be first in that process, and you'll own the IP as a result of that. So it's worth completing the exercise. It's worth building that IP strategy around there. It's certainly, from our perspective, worth doing that freedom to operate analysis. As I said, making sure that we are not going to infringe on anyone else's IP, so that we don't have someone come after us later on and stop the business that we thought we were building, whether that's in this jurisdiction or in a different jurisdiction. So I'd certainly encourage everyone to reach out to the experts that are here today. If you haven't already set up one of the one-to-ones, I'll certainly be reaching out to some of them. Do take advantage of the financial resources that are there, and those contacts through the local enterprise office. It is an investment in cash that you do put in to begin with, and it's always difficult to balance that with maybe driving new revenues or allocating it off in a different area of your business. But the reward on investment in this is significant if you can get it across the line. So that's my journey to date. As I say, I'm by no means an expert, but I have felt the pain of it, and I now, even at this point, are picking up and trying to develop our own IP strategy.
Okay, Claire, thank you. Can I ask a question? Just so in the context of your own business, are you looking at a specific or protecting the piece of software or something particular that it does, or?
So our software then generates this unique security score, and we have an algorithm that sits in behind that. And that's where the intellectual property potential lies within it. So we will have trademarks in terms of the name for our product, and we look at all our patent potentials around that. But the real patent will be on the algorithm side of it, Michael. And as I say, like, we do want to be internationally scaling, so we want to make sure that we have it right now at this point before we go much further in our journey.
Perfect. Okay. Thank you. Thank you. I think we have one other question. I think we might have had a question there in relation to, can you get funding under the IP Start and the EU SME grant? So I don't know if any of our panelists might have seen that. They can either come in and answer, or they might just put an answer online there in the chat box. But that was just a question. I suppose, really, can you get double funding? One from the EU and one from Enterprise Ireland? Yes, James?
Yeah, I answered.
What did you?
I suppose in part, very briefly, the IP Start is around the strategic part, and the SME fund is for the filing costs for the IP, whether it be a trademark, a design right, and recently patents. So in the main, they're non-overlapping activities. Yeah.
And I know that we take a lot of this for granted, but just in case somebody, it was touched on before there about getting EU-wide. I know historically there was EU, there was North American, there was Ireland, there was England. I assume that is still there, and these are, you can take them for a year or 3 years or whatever, and there's a cost for each one of those. Yes.
Yes, and to be honest, maybe the easiest, and David sources as well on the Irish Patent Office, or Intellectual Property Office, I should say, but the fact sheets that I referenced earlier really talk to that for each type of IP, the process, the kind of cost, the search part, etc. So what I might do afterwards is send some specific links for the key IP types.
Perfect. I'm just conscious we're at 15:26. I know that there's about 50 people registered for the one-to-ones. All of our speakers, I think, are registered to provide those one-to-ones, as well as Eileen here in the office. And I'd like to acknowledge Mary White as well, who's an expert in branding and IP. So they will be available in the next 3 to 4 minutes. So again, I'd like to thank our speakers, David, Richard, James, Joe, and Claire, for contributing this afternoon, and also thank them for their time because they're remaining on. So if you're with us, you will log off, and if you have your one-to-one meeting, go in through your link that you received by way of email on the B2 Match, and hopefully you'll have your 15 minutes, and we'd ask you or your expert that you're meeting to keep a close eye on the time. And because if you go into 20 minutes, you're taking 5 minutes of the next person that's meeting that expert. So you have a 15-minute slot. So thank you all for logging in, and thank you for your time. And we just like to acknowledge, I suppose, as well, our contribution and help from Geraldine Byrne of New Frontiers and our colleagues and Leitrim and Sligo Leos, who assisted Eiling and ourselves here in Donegal put this afternoon's event on. So thank you very much for tuning in, and wish you well in your one-to-one meetings as well. Slán go fóill.
Thank you.
Thanks, everyone.
All right.